Can you hear me, Scarlett?
I can.
Okay, and we are live. Welcome everyone to South Carolina for Criminal Justice Reform. My name is Ali Menegakis. I'm the founder of SC for CJR, and today I'm joined by Keith Smalls, who is an executive board member on SC for CJR, and we're super excited to have Scarlett Wilson, who is the solicitor, the elected solicitor, aka prosecutor in Charleston and Berkeley County. I'm going to be introducing her in a moment, but as I always do first, I'm just going to introduce you guys again to what South Carolina for Criminal Justice Reform is and what we do. So South Carolina for Criminal Justice Reform is a 100% grassroots, nonpartisan organization, and we're dedicated to holistic criminal justice reform throughout each stage of the criminal justice process. Our team is composed of criminal justice reform advocates from all different backgrounds, including criminal defense attorneys, public defenders, former prosecutors, formerly incarcerated individuals, academics, and other people that are just passionate about reform in our state. Our motto is fairness, awareness, and change, and we're dedicated to unveiling the injustices throughout each stage of our process. Today, we are having our second episode of Justice Unveiled, and today we're focusing on the role of the prosecutor. And today we're grateful to have Scarlett Wilson, Solicitor Wilson, with us to tell us and educate us on what the prosecutor's role is, what some of the challenges are, and what proposals she thinks should be implemented and things that she has already done to help criminal justice reform and to make our system better. So welcome everyone. Scarlett, welcome. Thank you for being here.
Thank you. I'm so impressed with what y'all are doing. I've gotten to see some of your videos and it's impressive. Heavy lift.
Thank you. We're loving it. It's going fast, but we're enjoying every part of it. Right, Keith? Oh, Keith, I got you on mute. There we go. There you go.
Yes, it's definitely going fast. Again, I like to welcome Scarlett Wilson, a good friend of mine. I appreciate you being here. Been looking forward to this. Glad to have you here. So again, I'm Keith Smalls, Executive Board Member for SC4CJR. Today's topic is on prosecutor's role. And who better to explain that than the prosecutor herself, the solicitor, Scarlett Wilson. So we first definitely want to get into that question. The prosecutor's roles, Mrs. Wilson. How would you explain the prosecutor's role?
Well, we take over cases after law enforcement has investigated, and we then prosecute those cases. We make all the decisions after arrest as to whether or not someone should be prosecuted for a crime, whether or not a case should be dismissed, pled down, sent to pretrial diversion, you name it. Once an arrest is made, we take it from there, and our role is to seek justice. One thing that I think people don't realize, and I'd like to shed some light on, is our role is not just to obtain a conviction against someone. Our role is to figure out a fair resolution based on the evidence that we have. And sometimes that means that victims aren't always satisfied with the results we get based on the evidence we have. We look at aggravation, things that make a crime more serious or more concerning, and we look at mitigation. And unlike other lawyers in the system, that's our job, to not only consider the community, to not only consider the victim, but to also consider the defendant and what's going on with that person. And so we have to really wear a lot of hats and can't be one-dimensional.
Sorry, Keith, I had you on mute. Go ahead.
Had some background noise, but definitely, we're definitely learning as we go with the role of a prosecutor. You definitely wear a lot of hats. We're going to dive into some other topics in regards to criminal justice and the prosecutor's role. I definitely wanted to get into bond reform Maybe we can talk about that because I definitely want to know the prosecutor's role in bond reform. I learned some interesting things as being a community representative for the CJCC and a lot of the bond reform work that they've been doing there. And in fact, we were at a meeting not too long ago where it came up, and you know, it's just a lot of things that people, are not aware of when it comes to bond and bond reform. There are a lot of questions there, but there's definitely a role that the solicitor plays in the bond hearings. And I definitely want to get your input on that and even some of the things that you're doing with the CJCC in regards to bond reform.
Well,
And let me jump in there, Scarlett, let me just define a few things for our viewers here. The CJCC, when Keith talks about that, that's the Charleston County Criminal Justice Coordinating Council. All of us here are actually members of that council. That's where Keith and I met. That's when I first met Scarlett, actually, also when I moved here. And there are different stakeholders from all parts of the community that collaborate monthly, and more than that, in different group meetings to talk about reform, specifically when it comes to bond and pretrial detainees, people that are in jail because they can't afford to pay their bond, and trying to work out different ways so that they're not just in jail because they're too poor to post that bond. And Scarlett, Solicitor Wilson has taken a lot of big strides here in Charleston to help move forward those goals that we have at the CJCC, which is a program that really was started from the MacArthur Foundation that gave Charleston, I think, almost over $4 million, if I'm not mistaken, if that's right, something around there.
It's about that now. And
a few years ago.
If I can kind of just dovetail from that, the CJCC, the Criminal Justice Coordinating Council, if you're watching, please follow us on Facebook, and there's so much information there about where Charleston's been, and we'd like to move this into Berkeley. One benefit of having my office involved is Berkeley County does get some of the benefits from what we're learning here in Charleston, but we actually started looking into reforming the CJCC at the end of 2014, beginning of 2015, and seeking MacArthur Safety and Justice Grant, which we were successful in succeeding. And I was one of the partners that pushed for that and got actually the Chief Justice at the time to sign on. And that was a big deal because nobody in the country had their Chief Justice as an ex officio member. What the goal of the MacArthur grant that we got and what our commitment was to safely reduce the jail population and to ensure that we were addressing racial disparity and disproportionality. So that was 2014, 2015, well before the tragedy at Mother Emanuel and the Michael Slager case. We were looking at these things not as reaction to those things that happened here, but to be progressive and to be forward in criminal justice reform. And so we got the grant, and one of the big things we started studying was bonds and who got bond, who didn't get bond, and collecting data on those things. And from that data, we saw all sorts of interesting things, disturbing things, you name it. But what we learned was that, and we knew this, but now we had the data to support it, because it's not enough to have anecdotes and someone to talk about their cousin or their friend or their client, but to show patterns across. That people were being held not because they were dangerous sometimes, but because they were poor. And that is just unacceptable. That is not how the system is supposed to work. If someone is being incarcerated pre-trial, it needs to be because they're a danger to the community or they're a serious flight risk. And so we set out adopting several things that could help ensure, one, that people came to court, and two, to see that judges were handing out bonds, which basically is an insurance policy, right? It's where a person who's been charged puts up money or a promise to pay money if they violate conditions of a bond, if they don't show up, if they commit another crime, that sort of thing. So we created and other states have done this, we created a risk assessment tool. And the goal of that was to ensure that people who had been charged were judged on the things that were relevant to bond and not judged by the color of their skin. And that they also were judged and that bonds were granted based on those two factors, danger to the community and flight risk. And that we didn't trap up people who just couldn't afford a bond. I mean, if someone is arrested on a low risk crime, you know, a malicious injury to property, a larceny, and they have a bond set at $5,000 or $10,000, most likely a judge who set that bond didn't think that person was dangerous. You know, a $5,000 bond doesn't seem much unless you don't have it, right? And so we saw people, even on low bonds, being held longer than they needed to be held. So we studied that. We also looked into ensuring, especially on these low-level offenses, what was happening too often is that people were maxing out their punishment, you know, their 30-day punishment. They had already served their time and they were still being held. So we were auditing those sorts of things and reducing the jail population that way. And it has been a tremendous success. The bondsmen, many of the bond companies don't like what we've done because it has meant that more people were released. Now, anybody who's followed me knows that I also talk a lot about revoking bonds. But I believe there has to be a balanced approach. When I'm talking about revoking bonds, I'm talking about dangerous people and people who have continued to reoffend, not people who are going to lose their job or going to lose their family because they've been charged with a crime that it's going to take us a while to get to, and there's really low to little risk that they will hurt anybody. So I rambled there for a minute, but
No, that was great, Scarlett. I just want to chime in there a little bit too, in terms of Charleston receiving that Safety and Justice Challenge grant. It's my understanding, at least when I went to the All Sites meeting last year, that we were really one of the only Southern states. I mean, I'm from Florida, so I don't consider Florida the South. So a few parts of Florida did get it, but in terms of Southern states that really, one, had an interest in this grant and progressing in that way towards the goals of the grant, but two, that received it. And Charleston was one of the first counties really in the country to get this grant. And it was really a big deal. And we're actually going to be hosting the CJCC, the Charleston County Criminal Justice Coordinating Council, in a few weeks. So we'll get into a lot more about that and how exactly they form the risk assessment, what the good things are, what the challenges are.
Yeah.
We're going to be having the executive director and the chair come in and join us and talk about
Get
that.
ready for some data.
Yes.
We'll bring it.
They have lots of data and they have a lot of great information. You can download all of their annual reports, their semi-annual reports, to actually see what the numbers are here in Charleston. It's really interesting. So I encourage you guys, we'll put a link to that after.
Yeah, it was a big plum for us to get it. And again, I think part of it was when we had the idea, actually kind of came up with it and went to Ashley Pennington, our public defender, and said, let's go make a pitch to the Chief Justice and see if they will support this. And the MacArthur people went nuts over that because it just hadn't been done anywhere else. And I think the other thing, you know, understandably, law enforcement is facing some pretty brutal scrutiny, again, understandably. But people in Charleston need to feel good about the fact that law enforcement has embraced this challenge so much. And it's interesting because sometimes when I read the critiques of maybe my office or me, or the critiques of law enforcement, I feel like I'm reading some canned report about some other state. And I give you an example. Not too long ago, there was a headline in our paper, and I had it pulled up. South Carolina has the second highest rate for marijuana offenses. Okay, well, I'm sure that's true. But way down in the article, you got to what we've done as a result of the CJCC and really studied it. Since we got the grant, we reduced the number of single charge bookings for simple possession of marijuana by 93%. You don't do that without law enforcement being on board. And they really embraced the cite and release options. They have really looked forward to having a sober center, you know, some place to take people who are intoxicated and don't need to be incarcerated. The mental health aspects that the CJCC has really brought forth, given us some options to treat people who are mentally ill and aren't or wouldn't be committing crimes but for their mental illness. So we have a long way to go in this country for criminal justice reform. Charleston's leading the way, and we need to feel good about that. We aren't there yet. I'm not saying we need to rest on our laurels and have a party in the street about it, but we are moving in the right direction, and we will continue to lead with reform.
And I just want to define one thing for our viewers that might not know, if you don't mind just a second, Keith. When Solicitor Wilson talks about cite and release and the reduction by 93% for marijuana bookings, what she's saying is that, you know, before the CJCC came here in MacArthur and we started collaborating with law enforcement in Charleston, what happens, and happens in most of the rest of the state and a lot parts of the country, is that if someone is found to have marijuana, a small amount of marijuana on them, what would usually happen with the police officer would arrest that person and take them to the jail, where they would be booked in, which we say processed, and go into the jail and then go to a bond hearing or post their bond. But now what they're doing for a good amount of the cases, instead of arresting them and taking them to jail, they're writing them a ticket, similar to like a traffic ticket you might get for speeding. So that has really reduced the amount of people that have to go to jail for such a low level offense, and also may not be able to post that bond and are stuck in jail just for a small amount of marijuana.
And then they lost their job.
Right.
Yeah, so that's definitely, you know, I can talk about the CJCC a lot, and we definitely look forward to having them on and having that conversation in depth a little bit more. But I definitely wanted to get on the police, law enforcement, you know, side of things, especially in light of all the, you know, all the heat that they're getting now with the George Floyd issue. I understand the Walter Scott and the Michael Slager issue that we really can't talk about because, of course, it's an appeal. But we want to talk about to what extent does a prosecutor work with law enforcement in their role? You know, just to give people an understanding of the prosecutor's role with law enforcement.
Well, you know, it's a complicated relationship. And it's funny, when I go to conferences across the country, I hear the same things from DAs from across the country. And one of the reasons it's complicated is because we're the check and balance. We're the check on law enforcement, and we're the Monday morning quarterback to law enforcement. And, you know, really nobody likes a Monday morning quarterback. I get to sit in my cool air conditioned office and judge what they should have done, what they could have done in a case, what evidence I wanted to see. I can ask them. And one of the sort of misconceptions about being the solicitor in South Carolina, it's different in other states, but in South Carolina, is that I control law enforcement and I can make them do things. I can't. But at the end of the day, I decide whether or not a case is going forward. So most of the time they want to do what I ask them to do to make a case stronger, whether it's interview a witness or subpoena something or conduct a search warrant. You know, we work together. So while we have a close relationship in a lot of ways, most prosecutors always want more evidence. I mean, we want the strongest case possible. Many in law enforcement always feel like their case is buttoned up right at the beginning. So there's that natural kind of rub on looking at cases. The other thing is, as we talked in the opening, I have a responsibility to justice, to the community, to victims, and to defendants. And that means I have a responsibility to call out officers when they don't do the right thing. And fortunately, it's few and far between, but there have been officers that I have reported and prosecuted, not just Michael Slager. And I can talk some about that trial. I don't want to retrial the Slager case. We've got a lot of things to cover, but you know, it is a complicated relationship. I have a lot of respect for law enforcement, but I also see a lot, and the good officers are the ones who are eager to learn, who want to know, why is it that you need that? Why can't I do this? Why is it a problem? You know, if somebody's invoked their right, if I go back to them again, because I have another question I didn't ask. Well, it's a constitutional problem, and we can't do those sorts of things. And if the system collapses on those types of issues for one case, it collapses for all of them. And it's rewarding to work with officers who want to learn and who want to do better and who don't mind a critique. But I suppose it's natural when you feel like you're critiqued all the time to have some, I don't know, resentment or some challenges with the person who's always doing that, you know.
Solicitor Wilson, can I just break this down first? Maybe some of our viewers that don't know exactly how the process works. You know, the law enforcement, you watch, you know, I don't know if people still watch Law and Order, but the intro to that, what was police officers, you know, investigate crimes and the prosecutor prosecutes the crime. So, you know, if you call 911 and someone breaks into your house, then a police officer is going to come and they're going to investigate and they're going to write reports and collect evidence. And here in South Carolina, you know, that officer will then go to a judge and get a warrant signed for the arrest of that person, or maybe, you know, before their bond hearing. And at that time, you know, your office, Solicitor Wilson, still hasn't really touched that case yet. That is still in, is that correct? In the
Right.
police office?
Yeah, and it's different in other states, and
Right.
especially in this area where we have so many people who have moved from other states, they have a different view of what the solicitor's office, or in probably where they came from, the prosecutor was probably called the DA or the state's attorney. In South Carolina, much to my chagrin, we don't have warrant approval.
Right.
So my office, in a regular case, will not know anything about the case probably until a month after an arrest. You know, if it's something major that law enforcement needs our help on and they want advice on, they'll come to us and we will give advice and we'll try to guide in a way that is productive. But for 99% of the cases, we don't know about it until a few weeks after the papers are transmitted from law enforcement. So we're playing catch up. In other states, there's a warrant approval process. Other states have an active grand jury. We don't have that here in South Carolina. So we can't call witnesses to a grand jury to further investigate a case. The Attorney General has a grand jury for certain very few limited crimes, but for most of our cases, that's just not an option. So we're kind of playing catch up from the start.
And Solicitor Wilson, so here in South Carolina, we do have grand juries for state level charges. And they are the ones, you know, that's a private proceeding. The solicitors there, people from the community that serve on that grand jury, and they determine whether there's enough evidence to actually charge someone, as we call it, indict someone in this state. Versus some other states, for example, in Florida, where I came from, the prosecutor, the solicitor, the DA has the authority to actually file what we call an information or a charging document without having to go to a grand jury. But here that doesn't exist. Is that right?
Right. We can do a direct indictment, but we couldn't proceed to trial on a direct indictment, which would be akin to an information. We only use direct indictments for situations where the defendant and we agree that we're going to proceed on this charge, usually for a guilty plea. But you know, one of the points that you're making about utilizing the grand jury is, you said the solicitor's there. I'm not even there. The grand jury is just the officer presenting the case. We can't go into the grand jury with the witness except to explain legal principles to the grand jury. So if the grand jury has a legal question about the law, they can summons someone from my office, either me or one of my senior people, to answer a question about the law. Unlike other states,
yeah. I did not even know that. And I mean, that's, I guess, another thing about how private these grand jury proceedings really are. You can't get records of them. You can't really get information. I'm sure even your office can't get that.
right. There's no transcript. There's no nothing. And it's kind of archaic. And it would be nice if we had an investigative grand jury so that we could get testimony on the record and that we could ensure that evidence and testimony was tested in some way before an indictment.
Good stuff. Yeah, definitely. That's why it's just such a beauty to have you here. And, to get this information, a lot of stuff that even Allie doesn't know, and I think she knows a little bit of everything. So definitely, I kind of wanted to talk a little bit about the George Floyd issue, in a sense where, just to ask the question, and I mean, if that had happened here, what would your role as an election prosecutor, like, what would your role have been in that incident had it happened here?
Well, I'm gonna give you a long answer to an easy question, because that my role has evolved. South Carolina has no statutes, no requirements, no nothing governing officer involved critical incidents. That's what we call them, officer involved critical incidents, OICIs. And even before the Michael Slager case, I was frustrated by there being a lack of uniformity, even in the cases I was getting from the same agency. By sort of culture and by practice, most agencies call in state law enforcement to investigate, and that's a good thing, an independent agency. But even amongst the state agency, what I got would be totally different. And it was frustrating for me to not be involved, as I mentioned earlier, in an investigation. And all of a sudden I have this file on my case and everybody's asking me what's going to happen with the case. And so then we moved through the Slager trial, which I'm one of very, very few prosecutors who's tried an officer for murder. It just is very, very rare to happen. And one good thing about trials is evidence, policies, procedures get tested, and you learn from those things. And I learned a lot from that trial and that investigation. And one thing that we did as a result of that and the prior concerns that I had was develop an officer involved critical incident policy or protocol. And we did that. I asked the prosecution commission, the statewide commission, which I'm on, to develop an outline for prosecuting these things, sort of a wish list, what should happen. There's 16 solicitors in the state. There's 16 different ways these things were being handled. And in some ways that's okay because of the different sizes of our circuits, the different sizes of our counties. They're different requirements. Charleston is not the same as Dillon, is not the same as Aiken. And so there needs to be some flexibility. But one of the things that the commission recommended, and I agree with, was what we asked for was a public integrity unit. And some other states have this, and that's a unit that would be made up of seasoned veteran prosecutors, seasoned veteran investigators, a crime scene group that would do all of them in the state. They would be a special force in the state to investigate officer involved critical incidents. Well, obviously that would cost a boatload of money, and that was not going to happen. So the fallback position was each solicitor needs to come up with a protocol for their circuit. And so we did that. I worked for a year on that with law enforcement, members of the community, academia, to come up with our policy. And we have gotten great feedback from across the country with what we develop, because a lot of prosecutors' offices don't have them. So anyway, to get to your question, as I mentioned earlier, we don't have warrant approval in South Carolina. So there is no legal requirement that I even become involved in an officer-involved critical incident. But because they are so serious, and because the public is so concerned about them rightfully, our local law enforcement embraced the idea of the formal policy of what is to happen, and that is to get the solicitor involved immediately, and to have certain benchmarks in the investigation where I am, when called upon, authorized to answer what's going on with an investigation, to help with the charge. Because of the varying or the difference in what it takes to get a warrant, which is what law enforcement wants, they want probable cause. As a prosecutor, probable cause doesn't carry the day for me. I need proof beyond a reasonable doubt. So that's another thing that interferes with the relationship between prosecutors and officers. They are going for probable cause. We're going for proof beyond a reasonable doubt. And the best officers want to go ahead and get me that proof beyond a reasonable doubt. There are times with public safety where you have to make an arrest just on probable cause because the situation is so volatile or dangerous. But the status and the state of where we are now, to get to your question, if George Floyd had happened in South Carolina, what I imagine would have happened, because probable cause was clear as day in that sickening video, I think law enforcement, state law enforcement, would have made an arrest immediately. After that, I would take the evidence, collect the evidence, including an autopsy, including any body cam videos, any bystander videos, and then take from what law enforcement charged, then move to the next step of seeking the indictment that Allie was talking about. But I would imagine in a case like that, like the Slater case where SLED made an arrest immediately, I think that things would have moved pretty quickly by law enforcement, and then later by me with the grand jury and an indictment.
And how would it have worked, Solicitor Wilson, how would it have worked? For example, there was a lot of scrutiny after George Floyd was killed that, not all of the officers were arrested. How would that have played out here? Would it be the same process for each of them? Because I know that a lot of, people were upset with the prosecutor there and with the police there for not charging them immediately.
Yeah, and frankly, when you get into that, it's hard for me to say because I don't know what the evidence was on them. But I think the analysis would be the same. If state law enforcement felt like they had probable cause on the other officers, mere presence isn't enough. I mean, just because they were there does not mean they're guilty of a crime. And I'm not privy to the other videos. I haven't seen if there are other ones that show what the other officers were doing. But I would think that for each officer, there would have been an analysis by law enforcement if they had probable cause. And then after that, if that were here, I would review that, ensure that I agreed with that and what they charged, and then make a call as to what to present to the grand jury. The same thing that the cops charged, that SLED charged, or would I change it in some way? Would I up it? Would I lower it? And that would be in my discretion.
And that's an important thing, I think, to focus on too, is one of the, I think, best parts of a prosecutor here in our country, as opposed to other countries, is that the prosecutor has discretion to not only, in terms of sentencing sometimes, and we'll get into mandatory minimums, but also when it comes to charging. The prosecutor is the one that brings the charges, but also can get rid of the charges, dismiss it, enhance it, reduce it. And each prosecutor has that discretion, and that is what's so good about that they can look at a case by case analysis of each one.
Right. The George Floyd situation, I'm sure I felt much like y'all did when you saw that video. I think, I hope a lot of good's going to come out of it, though. I really do. And I think, a lot of people ask, why was it different? I mean, the Walter Scott video is horrific. I think one of the reasons that George Floyd is having such an effect is it was so long. I mean, it just went on and on and on. And people can't sit in that discomfort, and that discomfort is calling people to action. And again, I hope that will mean good things for all of us in reform.
So definitely, I want to kind of use that as a segue into fair prosecution and the racial bias that's obviously everywhere. It definitely played a gigantic role in the George Floyd issue, even Walter Scott. I mean, I've been victimized by racial bias with my sentence and being formerly incarcerated. Uh, but the question, like, what have you done to educate your lawyers, in regards to racial bias?
Well, again, for some time, especially since my involvement with MacArthur, we've learned so much. But even before that, I've made it clear in my office, like, for example, I haven't seen one of these in a long time, but it would be, African-American male riding a bike without a bell or without a light is stopped. And it's like, I don't have a bell on my damn bike. I'm not getting stopped. And I've made it clear that, I mean, those kinds of things we just don't have the patience for. But again, you can't act on anecdotes. You can't call out a particular department or even a particular officer on one situation. You have to have the data to support all of this. And I think even before it became kind of the word of the day or the cause of the moment, we were looking at systemic racism, institutional racism, implicit bias. I have no doubt that I don't have any flaming racists in my office. If I did and I knew about it, they wouldn't be in my office. But what I have learned and seen and what studies are showing us and what people have to understand and accept is that we have, first of all, institutional racism that was created by design. And that's not something I grew up knowing. I went to school in the corridor of shame, and I was lucky that I had some great teachers and I had good parents and I learned a lot, but I didn't learn about all of that. It was not taught in my South Carolina history books. And so as I've learned about that, I've introduced this to my office, and what we see across every industry, healthcare, education, criminal justice, all the government, all of our big institutions have this racism sort of baked in, which then leads to implicit bias, a bias that you don't even know you have, that you're unconscious, that you would be shocked to know was affecting your decisions. And so one of the first things that I was introduced to, we had done some diversity training and we had done just a little bit of implicit bias training. But then I learned about the groundwater training that is put on through the YWCA, and Tina Singleton and LaVonda Brown brought the Race Equity Institute here. And we put our office through the training. Now, if you want to see me jumping up and down, I was begging and pleading and screaming for MacArthur to help pay for us to go to the training because it's very expensive, unfortunately. And it took a lot, but finally they matched half of the training. And then fortunately, Charleston County ponied up the other half. And I will tell you, it was uncomfortable. It was emotional. It was transforming. It was inspiring, disturbing. It was all of those things. But to do this work, you have to be willing to sit through that and to work through that to learn. So we did that in 2 phases, the whole office. At first, I was just going to do prosecutors. And then I thought, well, maybe I need to do investigators. And then I realized, no, our whole office needs to do this. All 150 of us need to do this. And so I got the judges on board to give us protection, so we didn't have court for I'm getting some feedback there, but anyway, so we did this training, Keith, and like I said, it was life-changing, I think. And so the next step is to take what we've learned, because that training set up how we got to where we are. And now what people have to do is dig deep and look inside and test themselves on implicit bias and unconscious bias, because I believe that the bright side of all of that is that I think we can train our way and educate our way out of it, out of having that kind of bias. And so on top of that, what we're doing, how it affects everything on a day-to-day basis is back to the data. Now, all of my prosecutors have to enter what their sentencing recommendations are. And if you know lawyers, entering data is not something they think they went to law school to do, but the times are a-changing and they are learning, and it's been hard, not because they didn't want to do it. They're on board. Everybody is on board. But it is more work for them, and it's tedious work to enter this data of what their offers are. And so what we'll be able to do is be able to see, are white people and black people being treated the same way in their offers or in their sentence recommendations? And if they're not, why not? It's not enough to just say, okay, we have this person charged with armed robbery and this person charged, and they got a different sentence, so there must be racism. There could be different things that affect that, but we have to start somewhere, and we'll start with the data. Then we'll do the deep dive. If there is disparity, why that disparity is there. And is it a particular person? Is it our office as a whole? You name
it. And Solicitor Wilson, what was your biggest takeaway from the racial bias training that you did and that you presented, at your office to your entire staff?
The biggest thing for me was really in the lead up to it. Well, first of all, that all this history was out there that I didn't know. Like, there's a whole story about Wilmington, North Carolina, and I love Wilmington. I love going there. I think it's a very cool town. But there's a whole history there about African Americans and how successful they were in building that city, and they pretty much got wiped off the map and run away. I mean, but that was happening all over. Stuff was happening with banking. Stuff was happening with healthcare, and the way that things were rigged so that African Americans couldn't succeed. And so that, of course, I knew that there were disadvantages, and that wasn't new. And that it certainly, racism as a whole wasn't new. I didn't know how designed it was from long ago, long ago. But what I think for me kind of rang bells was when I was in the initial, they did like an executive summary training for leaders in the community just to get a little taste of it. And when I saw the studies, I like data, I don't like anecdotes, I like seeing the studies. When they did studies of preschool teachers who love every child in that class, they would give them the shirt off their back, they take them home, they feed them, they do, you name it. Black teachers and white teachers showed bias in how they treated those children, and they didn't know it. And when those things were revealed to those teachers, their devastation that they were infected with it. Same with nurses. People who are really giving their life to helping others, again, not just white nurses, African American nurses too, showed bias in some of the studies. And once presented with that, being devastated by it, what it made me realize is that these are all good people that have been infected by our institutions and this setup that we have. And I thought to myself, if those people have been infected, then I know that I have, and I know that people in my office have. And our whole country has. And I think, I'm sure somebody's going to take a segment of that and use it against me, but I'm trying to be honest and frank about this and show that if you aren't willing to look inside and realize that you've got it too, then,
And Solicitor Wilson, you have a database that you have been collecting data about offers, but you also have made a good amount of things public for the public to look at as well. Are you planning on also including, racial statistics in that public database? I don't believe it's there right now. Why is that? And is that going to be in the future?
I think that the data is there. Like, I think you can tell the race of the people involved. It just hasn't been analyzed yet. So let me be clear, and this is getting kind of wonky here, but right now, only our sentence recommendations are there. What our next step, what I want to do, because in the people I'm working with, and you're going to hear more about that in the next few days and weeks, but what we realized was, are Black people and white people starting at the same place with offers? And to study that, nobody in the country is entering that data. We're getting ready to be. And that's going to be groundbreaking across the country. What I want to create, my idea is what I'm calling a plea portal. And so for you and me, Allie, what that would mean is I type in the data of my offer to you on X defendant. Your counter offer comes back to me in that portal. Because let me tell you something else. While my office and every prosecutor and every person in this country involved in prosecution and law enforcement may have implicit bias, you know who else has it?
Criminal defense attorneys, yeah.
Right.
Everyone, but yeah.
Yes, we all have it. And we've got to be willing to look at it. And so what we'll be able to see is, did we start with at the same place? Mm-hmm. And did you come back with the same type of counter that you, for white people and Black people? But we got to build that. And I have gotten the software people interested, and it's going to, once again, it's going to cost, but it will be incredible. And the people that I'm working with at universities in other parts of the country are wowed by this concept that we're getting ready to venture into. Again, it's going to be more data entry for my prosecutors, but eventually what we'll be able to do is study all of that, see the patterns within my office as a whole, see the patterns if they're individual prosecutors, and we'll be able to study other things too that don't just go to race, but what departments are having their cases dismissed most often for lack of evidence, or how many cases are dismissed because there wasn't cooperation from the witnesses, that sort of thing. So there are other uses for this data, because we also have, and again, most prosecutors in this country don't have this or track it. We have about 25 codes that you enter as to why you're dismissing a case. So we can now, once we get up and running and have the people who have the know-how to analyze it, why are we doing what we're doing? And that's going to be critical.
Good stuff right there. I definitely want to move on to something that's near and dear to my heart. Of course, SC4 CJR. I think we're grounded on criminal justice reform. And again, that has definitely became a hot topic, a hot button issue, so to speak, especially at this time being election time. But there's been a conversation that has come up on the truth in sentencing. And I think you were a part of an article about it, and I definitely want to get your input on it. I mean, we spoke previously about it. I kind of think you gave me a little relief because I've definitely not been a fan of truth and sentencing, but you definitely gave some clarity to it. So I would ask that you would be able to kind of speak on truth and sentencing and what does it mean, and how do you see truth and sentencing playing out?
I bet, Keith, we're probably closer on truth and sentencing than you have thought. Because what truth and sentencing means to me is saying what you mean. Everybody in a courtroom, including a judge, needs to know what a sentence means when they walk out. And that's not the case now. I think we need balanced sentence reform. And that's not something that I've thought because of the campaign cycle. We've been talking about this for quite some time, or I have at least. And I have been on and consulted by members of the legislature on this. I was trying to look, at least 2017, if not before. We have to have a balanced approach. And I am going to take a hard line on violent crime. That said, I believe in safety valves. I talk about the federal system a lot because I was a federal prosecutor for quite some time. I'm still a special assistant U.S. attorney and have a great relationship with the U.S. Attorney's Office and federal prosecutors. But we have to reform our drug laws. And I have no problem with that. And I think there are a number of solicitors who agree with me on that. We had a meeting about that today. And as I said, we've been talking about it when there was a last bill that went through. One of the things that we said was, retroactively even on some drug crimes, reduce the sentences. I don't agree with retroactively changing the sentences on victim crimes. The other thing, I'm getting the sunlight in. The other thing that I see is that when people go to prison, on day one, we need to prepare for their release. If we're going to lock people up, we got to make sure when they come out better than they went in. And I think that we can do that. We can do both. We can be tough on violent crime, and we can be responsible and rational and reasonable when it comes to other types of nonviolent crimes. Let me see what I can do with the sun.
While Solicitor Wilson's doing that, I just want to break down a little bit about what truth in sentencing and how it works practically in South Carolina. So if you are charged and convicted with what's categorized, and some things are categorized as violent crimes, then let's say your sentence is 10 years. You, because you were convicted of a violent crime that is based on violent crime by statute, is my understanding, then you must serve at least 85% of your sentence. Now, had you not been charged with a violent crime, then you would only have to serve in the state 65 at the least percent of your sentence. Now, we had our first episode of Justice Unveiled featured Keith Smalls, and we went into details about his story and what happened to him. Now, Keith was charged and convicted with trafficking in cocaine, which I believe was a second offense at that time that he had. And his original sentence was 29 years. Now that was reduced later, I think, to 18 years. Is that right, Keith? But he had to serve 85% of that time in prison because trafficking in cocaine, most traffickings are considered violent crimes, whether you have a firearm with you or not. Solicitor Wilson, how do you feel about types of charges like drug possessions, like drug trafficking, being categorized as a violent charge?
I think that we need to revamp the whole thing. And that's why I say, I wish y'all wouldn't say you're against truth in sentencing. The problem that that I think y'all have is not with the fact that if you serve a violent crime, you have to serve 85% is what's considered a violent crime, right? And I think violent crimes need to represent what the general public thinks it represents. And that's something that is actually dangerous. That is an armed robbery. That is a rape. That is a murder. That is an attempt to do any of those things. I think domestic violence of a high and aggravated nature should be considered a violent crime. I think that strong arm robbery should be a violent crime, because if you beat me black and blue and steal my purse, that's an act of violence to me. That's going to affect my life. I don't think it necessary to consider drug trafficking that doesn't involve actual violence to consider it a violent crime. I'm not saying that we need to legalize drug trafficking and that we don't need to punish it. I'm just saying it needs to be recategorized. That's how I feel about it. And so I think we are on the same page with wanting our statute, our laws, our sentences to be in plain English and to be, Allie, you know how it is. You have to call the Department of Corrections to figure out what a sentence is going to mean. It shouldn't be that way. Everybody should be able to understand it. Now we can have a discussion about what fits into violence and what's not. And I think we are probably a lot closer than you think we are on that, like I said.
And Solicitor Wilson, we have a few questions coming up about this issue, if I can. One of our viewers asked, for truth in sentencing, what do you feel, Solicitor Wilson, about the role of corrections and their ability to exercise their discretion in fulfilling their roles in the system?
What concerns me about the role of corrections is it is often tied to their budget. And decisions are made based on budgets, not based on what's going on with the person. But let me go back. If we're going to incarcerate people, and especially those for a long period of time, but who are going to be returning to us, we've got to put money into rehabilitation. We've got to put money into ensuring that people who are in prison come out better than when they went in. I mean, it only makes sense. And here, some of the things that happen are just so backwards. And I talked about this the other night, Keith, when we were at that forum, and I'm beside myself about it. There is a place in Charleston that houses sex offenders who have been released. And it provides a holistic type of environment for them to get therapy, for them to have help with jobs, for them to have a place to live. The place operated for a long time and is still operating, but it's being threatened now because someone, a bureaucrat somewhere, decided to measure the 1,000 feet that it couldn't be from whatever other type of facility through a river, a ravine, a railroad track, not like just next door to something, but through the wilderness basically, and maybe even an interstate. They measured it from the back corner of the building instead of from the entry point where it had always been measured. And now it may be moved. Excuse me, not moved. It may be shut down, which means that these sex offenders that everybody should be concerned about have nowhere to go. So instead of having them receiving services, getting therapy, monitored, they would just be out on the street.
Yeah.
And those are the things that
yeah.
I don't get. And that's a little bit different than what we're talking about. But yeah. I firmly believe that, you know, we need some sort of reentry program, robust reentry program, if we're going to have these harsh penalties for people. And I think that that's the way to go. I think it's smart. And I think it's smart to take another look at what we do with drug crimes for sure.
Yeah, and I definitely want to add to that. in the state, for those who don't know, trafficking is anything over 10 grams. Of course, in our first episode, when Ali did the interview with me, she kind of gave a pictorial of what that may look like. But, I was given 18 years pretty much for 18 grams, and, never had a firearm, never, never toted a firearm, never used I never consider myself a violent offender. I never consider myself a criminal at that. But just wanted to give that little piece to you, that 10 grams, all it takes is 10 grams or over, and that's considered trafficking, which is considered violent. And I just also wanted to add a little bit about what the Truth in Sentencing Act did too, that, I think a lot of people don't speak about. It took away Pell Grants for incarcerated to get higher education. Um, and I think that kind of is in line with what you say. 95% of the people that go into the Department of Correction, they are released back into society. Um, I have this thing where I speak about the MacArthur grant. They have the Safety and Justice Initiative. Department of Justice have a crime and punishment model, but I like to talk about R&R, not rest and relaxation, but rehabilitation and reentry. And I often wonder why rehabilitation and reentry is not in the discussion more when we talk about criminal justice reform. But I mean, you definitely cleared some things up about the Truth in Sentencing Act in that regard.
Well,
But
yeah, I just want to be clear. When I talk about truth in sentencing, I'm not talking about a specific act. I'm talking about a concept. And the concept for me is saying what we mean. And I think we have failed the system. We have failed defendants. We've failed victims when we haven't told the truth about what kind of sentence they're going to be facing or that they've been given. And, politicians can put these stiff sentences on and then, undercut it with all sorts of leniency just to make themselves look good on the one hand. And, the other thing that happens sometimes it's bothersome, like I said, it worries me about retroactively reducing sentences that involve victims. I don't think you would face much resistance for retroactively changing some of our drug laws and releasing people earlier for drug offenses, because society has changed how it views drug offenses. And I have no problem with that. But when we are talking about victim crimes, a lot goes into those negotiations, those trials, those pleas, and to go back and retroactively release people, I think is wrong without input from the prosecutor and the victim.
I think that kind of gives us a nice segue when we're talking about, politicians playing a role when it comes to the criminal justice system. A lot of, our elected officials that pass these laws when it comes to whether truth in sentencing, or mandatory minimums is really where I want to get. A lot of them don't actually participate in, aren't defense attorneys, aren't prosecutors, and don't really see how that affects the day to day. But for example, a trafficking charges when it's 28 grams or more. And when Keith and I had that first interview for him, I held up 5 sugar packets. That's pretty much how much cocaine he had on him when he was charged and what he was convicted and sentenced to ultimately 19 years for. So just a little over that for 28 grams is a mandatory minimum sentence of 7 years. And that is not a discretionary when it comes to the judge. So if someone were charged with that offense and they went to trial and they lost, the judge would have no discretion, but must sentence them to at least 7 years. Solicitor Wilson, how does a prosecutor's role play into mandatory minimums? Does the prosecutor have discretion when it comes to those kinds of charges? What could you do? What can you not do when it comes to mandatory minimums?
Absolutely. I mean, think about it. We can dismiss a case. We can plead a case down. We can agree to a sentence on another crime or a lesser crime. So mandatory minimums certainly tie judges' hands. The problem with them is how they're enforced by prosecutors. One of the problems, the goal, one of the goals of mandatory minimums was to see that people were being treated the same, right? Well, if the prosecutor is reducing some cases but not others, what's going on there, and is that being done across the board? Is that being done fairly? So if a prosecutor does not reduce the crime or the charge to another offense that carries a different sentence, then the judge's hands are tied.
Right. And if someone is arrested and a warrant is procured by the police before it even goes to your office, for example, if someone has a prior drug trafficking charge, that mandatory minimum of 7 actually gets enhanced. I mean, we have some charges, trafficking and cocaine based 10 grams or more. If it's your third or subsequent offense, the mandatory minimum is 25 years for that type of charge with prior offenses in that category. But just the charge itself really gives a lot of power to the prosecution as well, doesn't it? Because that if someone is charged with that, they know that they have at least 25 years that they're looking at, unless the prosecutor uses their discretion to reduce it. And that puts a lot of power into your hands, into your young new prosecutors' hands as well, even experienced ones. How do you guide prosecutors and how to use their discretion? Do they have to go through channels to get approval? Can they use that? Are you monitoring that to make sure that they're being fair?
Yes, that we do have channels for that. And the other thing is, some of those crimes can carry life. Some of those drug crimes where nobody was killed, nobody was hurt, can, if there have been so many offenses. Now, I do think we get into a different category when we're talking about repeat offenders. Someone who is continually over and over and over again violating the law. But the way I try to guide my prosecutors is, again, looking at the whole of the case. Looking at, has this person only committed drug crimes? Has this person also committed armed robberies? Has this person continually beat up their girlfriend? What's going on with this person? Is this person using drugs or selling drugs to support his habit? Is this an addiction situation? Is there something we can do to fix it? Drug courts, for example. That's one thing, that's changed in prosecution since I start. We are on the forefront of diversionary courts, and we embrace them. But guess who doesn't fund them? The same politicians who are making the decisions about how much time somebody's going to do. And everybody likes the idea of drug courts, but they aren't giving money to it. Luckily, in the Ninth Circuit, we have county councils who recognize the importance of these diversionary courts. And again, when we reform sentencing, and I think that we will, along with reentry programs, there has to be funding for drug courts, because if these folks aren't going to prison, and we agree that many times they don't need to go to prison, there needs to be another kind of court, another kind of diversion that gives them some education and motivation to get out of the business, and to, if they are addicted, to kick their habit. And it's drug courts have done wonders, but they're very expensive. And I'm just fortunate to be in the Ninth Circuit. There's some counties that people just, they can't afford it. The county cannot afford to do the therapy, to do the meetings, to have what it takes to have the personnel involved to exercise the drug court. Wait 1 second, I'm gonna turn on the light.
Keith, did you have a follow-up for that? Because I did too.
Now you can go ahead, because I'll go after you.
Terrible problem with lighting as it gets darker outside.
That looks good. So my question with drug courts, and I've practiced in different jurisdictions, and each drug court can vary based on jurisdiction. And if it's my understanding that the drug court that we have here in Charleston County is similar to the one that I had before moving here, was that when you agree to enter drug court, you are agreeing, if you don't complete it, to being sentenced to a certain amount of prison time. Is that correct?
Sort of. When in our drug court, and in many of them, before you enter drug court, you've pled guilty and accepted responsibility for the crime, and you are given a sentence. That sentence is deferred upon your completion of the drug court.
And some things can, as a defense, I'll just be honest with you, as a defense attorney, I'm always so hesitant to have clients go into drug court.
Sure.
And in my experience, when I was at the public defenders here, I was managing, as you know, via the MacArthur grant, lower level charges. And I saw a lot of drug court offers for people that maybe had their first or second offense. And for those, I knew that if I went into court, I could probably get that client probation. So what was, the benefit legally for them to do that? Obviously their best interest, but that's not my job as a defense attorney, right? My job is to take care of them in their legal issues. And I always had concerns, like if someone that maybe, if they violate drug court, they don't complete it, then they're going to be looking at prison time. When maybe they would not have been. But it was the clients that, like you're saying, those repeat offenders, the ones that keep selling drugs, the ones that keep, having recidivism, those are the ones that I think would benefit from those programs. But again, like you said,
I would disagree that the people in drug court wouldn't be going to prison. I think most of them would be going to prison, but for drug court. There may be some exceptions, but on the whole, they're looking at prison time anyway. And the most successful drug courts that I've seen are that model because it keeps them motivated. Addiction is a monster. It is a monster. And what I think is good about drug court, or at least the way it's run here, and Judge Condon does a fabulous job with it, and the public defenders and my office. I mean, we all collaborate on how to, it's not a trap. We want this person to succeed and to graduate and to come back as a mentor. But the way it's built is it's built on an addiction model. And anybody who's worked in addiction or suffered from addiction or had a family member like I have with addiction, we know that they're going to fail. I mean, they're going to fail at first. And so we know that they don't go, it's not like, oh, gotcha, it's over. You tested positive, you're out. It doesn't work like that. It's built with the understanding that it's going to take a while for this person to break it. And usually drug court lasts 1.5 years, 2 years sometimes, depending on how many setbacks there are. Now, of course, if someone committed a violent crime while in drug court, they would be out, it would be over. But it's not, drug court sets people up for success, not for failure. And I think everyone involved agrees with that. Defense attorneys, of course, the courts, the therapists involved. It's a holistic approach.
Speaking of, I guess, drug court, definitely in the programs, arbitration program, I definitely want to.
That's near and dear to your heart.
Near and dear to my heart, definitely. I guess a little announcement that a week ago, you said you just signed my paper, so I graduated the voluntary arbitration program. So now I'm a certified arbitrator. With the Scarlett Solicitors program, and
I want you to tell everybody about it because we need volunteers. It is a wonderful program that if anybody watching is looking to give back to the community and to give back to youth, this can be it. It's not for severely troubled youth who are committing violent crimes and are deeply disturbed, but this program is for people who are getting ready to mess up. Mm-hmm. And arbitrators like you can help intervene. So tell them about it.
Yeah, it's an amazing program. I think it's definitely going to be a good help when you give a juvenile who's committed a nonviolent offense for the first time, and you tell them, say, hey, listen, we have this program. Within this program, you do have to admit your guilt, and that's all right. We're going to figure that out as well. But we're going to sit you down with your parents and with the victim and what you harmed, and we're going to, give some resolutions. We're going to give you a resolution, and if you complete this program, we're going to expunge your record, and you're going to get a second chance at life. I think in a nutshell that I mean that's just a great opportunity that you give a juvenile. I mean, I know myself. I was arrested as a juvenile for putting on my brother's coat, and he had something in his coat that I didn't know. I put on his coat and went to the store, but of course I lived in a high crime area, and the police see me walking with this big coat. I actually thought I had a gun on me. I was 14 years old. I was 14 years old. I never committed a crime a day in my life, and they found something in the pocket that I didn't even know was there. So I never told you the story, Ali, but I never told too many people about it. But I was 14 years old, and I was given probation. I was given probation and never committed a crime a day in my life. Had no idea that this was there. And I mean, I think if that arbitration program was there then, I definitely would have qualified, would have easily volunteered to take it and been grateful for it.
I
So
think one of the things that's nice about the program too is it helps the juvenile feel like they're not thrown away and that people in the community are invested in them doing better. And
yeah,
again, it's, they have to do some things they don't want to do,
yeah,
write some papers and
those,
confront some things they may not want to confront. But I think there is a feeling on a part of the child that people care and that they're invested in them and
yeah.
that there is hope for them, that we are not giving up on them. So I'm glad that you went through the training. How many hours was it? 21?
21 hours of training.
21 hours of training.
And,
COVID has kind of interfered a little bit with that, but we got
yeah,
innovative and got it done through
yeah.
Zoom, right?
Through Zoom, and it was definitely, like I said, it was definitely a wealth of information. It was so informative. Yeah, I mean, preparation is key. I think it prepared me to be an effective volunteer juvenile arbitrator, and I look forward to being able to sit down with these kids and give them the hope that they so desperately look for when it comes to the criminal justice system that usually is very that's usually void. But we definitely look forward to working with them and helping them get a second chance at life. So I appreciate you again for allowing me to get in the program, and I'm definitely thankful to be able to say that I am a certified juvenile arbitrator. So
We got someone at the door.
yeah,
Someone,
so yeah.
you want to go take there? Is that you? Scarlett, you got someone at the door there?
I don't think that's me. That's not you, Keith?
Yeah, that was my daughter, Pizza
Okay.
Man.
Okay. We're going a little over time, but I'm so grateful for every minute we have. There are just a few things that I definitely want to touch on before we let you go, if that's okay,
Sure.
Solicitor Wilson. Now, we talked briefly, about the challenges when it comes to prosecuting law enforcement, when it comes to, as you called it, officer-involved critical incidents. One thing that we have been focusing a lot here at SC for CJR, we've had a different program called Dissecting Police Problems and Solutions. And we had Professor Seth Stoughton on a few weeks ago from the University of South Carolina, who's an expert when it comes to police use of force and training. And he shared with us and educated us all about the use of force and lack of use of force policies here in South Carolina. And one thing that we learned through that talk was that there actually is no law in South Carolina that regulates when a police officer can use force against a civilian. And that most states do have some type of law on the books that regulates police officers. But because we don't have that, each agency is free to have whatever policy they want for that. And the law is really confusing when it comes to, because we don't have a law, so we have to look at the judge-made law, as we say, the case law, which has been very confusing in recent years, and can be argued that technically in South Carolina right now, based on the case law, that even a felony, an officer could potentially use lethal force to shoot someone that maybe even has just a felony warrant, and that would be okay under the case law. What are your feelings about not having, especially as a prosecutor where you have to prosecute police officers, what are your feelings and opinions when it comes to not having a law that actually regulates it?
I feel like it's ridiculous, and I lived it. I think I watched Professor Stoughton, is it? I watched that interview, and I hope that you will take his section and crop it or clip it and send it to every legislator that we have, because he explained it better than I probably can. But it's a real problem here, and he did an excellent job of basically explaining that our case law is baffling. And it sets prosecutors up for failure and communities set up for disappointment. And we can do better than that. And he said 42 states. Our research showed 41 states have these laws. And we need to have, everybody needs to know what the ground rules are for use of force. And officers should not be treated in the exact same way that citizens are. And there are some reasons for that. And some of them are, protective of officers. We expect officers to be armed. We expect officers to use force. So they do deserve some protections. We expect officers to rush towards danger when the rest of us run away. But we don't expect officers to let their anger or their fear get the better of them, and for them to act unreasonably and unnecessarily, especially when a person is not armed and dangerous. So after the Slager case, in also pushing for an OICI protocol across the state, we also recommended that the legislature pass an excessive force statute, and we proposed one. It was a starting point. It was not the be all end all. It was a place to begin the discussion. And here we are, how many years later, and still having that discussion. It's time to act on it. We can do something that's fair and that gives the community a sense of comfort in knowing that these cases can be prosecuted at the state level, and that we don't have to rely on the federal level or the federal prosecutions in every situation. So I think it's important that we do it. I think it's wrong for victims, it's wrong for defendants, it's wrong for judges and prosecutors and defense attorneys to walk into court and not be sure what the standard is. Is it a reasonable person? Is it a reasonable officer? Do we have to prove? One of the things that the civil case, the US Supreme Court civil case did was take the subjectiveness out of it. In other words, they took sort of the proving of malice, which is what we have to prove when someone dies at the hands of an officer to prove murder. But to prove a violation of excessive force, we wouldn't necessarily need to prove malice in every situation, because what's more important than proving malice is that it was unreasonable and unnecessary. And I think anytime, especially when we get into talking about officers who have mitigation, they have real mitigation. Proving that they had malice in their heart and their mind and their soul is going to be next to impossible. Proving that they were unreasonable and irrational is not. And so I think that we need to be.
What I mean when you say malice, so people understand that, how that breaks down for a prosecutor and how hard that makes it to prove that.
Right. Well, malice is often described, and it's described in different ways, but when you hear a judge say that in order to find someone guilty of murder, that you have to find that they had an evil intent, that they had a wicked heart. Well, showing that someone had a wicked heart, and we can say all day long, you only had to have a wicked heart at that moment. If a jury has just heard a week of testimony about what a great officer this person has been and how they saved a baby on the side of the road and this, that, and the other, that's going to be difficult to show a wicked heart. It is sometimes impossible when a jury has sat there side by side almost with that defendant for weeks, and they aren't seeing that and measuring that against the action they saw. You know, the same, I'm sort of segueing into something else. We have the same issue when we deal with the person who's injured, the victim who's injured. You know, people want to get in their background. Well, that's not relevant to what happened that day or night. That has nothing to do with it. You know, the fact that somebody has a criminal conviction has nothing to do with what happened that day or night. And that shouldn't be relevant. Sometimes it comes into court. And unfortunately, sometimes jurors consider that. It's kind of like this. Domestic violence cases. What's the first thing people say, lay people especially, when they hear that a woman's been beaten by her husband or her boyfriend for the third time?
She should have left.
Why didn't she leave? And we're up against that. And it should not matter, but that's what many people think. Same situation can happen a little bit different, but what we're up against with child sexual assaults. People want to see a child molester as some, you know, ugly monster, nasty, dirty person. And when the defendant comes in looking like a mild-mannered reporter, it's hard for jurors to believe something so awful would come from that defendant. But the reality is child molesters can be charmers. That's how they get the opportunity. You know, and so we have to, as Judge Jefferson would say, disabuse their minds of these kind of preconceived notions. And those are situations where jurors look at the defendant and who the defendant is and where he's been and have these preconceived notions. When we move to officer-involved shootings and officer-involved critical incidents, what do we have being judged? The victim. You know, what if the victim hadn't done this or that, he wouldn't be killed. And many times the victim, yes, has been involved in criminal conduct. That's why the police are involved. But that doesn't mean that law enforcement gets to kill them, you know? And so we have to be honest about those preconceived ideas that people have and educate them through why this is not okay and it's not acceptable. So all of those are challenges that tie into the need for an excessive force. Those are the things that we're battling against when you have someone who has had scrapes with the law and had a scrape with the law that during that incident, but didn't deserve what they got, didn't ask for what they got, and the officer was out of line, wrong, and excessive. We aren't always going to be able to prove they had an evil heart bent on mischief, you know? So we need an excessive force statute is the bottom line. And I'm sorry, I got on a tangent with that.
No, I think that's really helpful. So last few things I think you already know, we've talked about this before, that one of our big things at SC for CJR, especially for me coming from Florida where there are these statutes in place, we are really big on hoping to get one day in South Carolina a speedy trial rule, and possibly, hopefully, depositions in terms of criminal cases. And I'll just explain that briefly and ask your opinion on it. Are you saying praying as in you want that?
Yes.
Thank you. I haven't talked to you about depositions yet.
No.
And it's just great to do that. Okay. So a speedy trial. So what one of the issues that we have in South Carolina and most states, especially when you have a limited amount of funding, unfortunately, for the judiciary, as is pretty much all over the country, there is a really big backlog when it comes to trials. in South Carolina, in Charleston, for example, and we are one of the more expeditious counties in the state, if I'm not mistaken, Solicitor Wilson, we are more efficient than some of the smaller counties, at least. We have a backlog of many trials, thousands in our county. And I think the average time to get to a trial can sometimes be over 2 years just in Charleston County. But a lot of people, every time I tell them about this, they're like, well, you have a right to a speedy trial. Oh, you sure do, under the United States Constitution, but that's not delineated, it's not enumerated there. So we don't really know how long that is. So what some states have done to make sure that people, aren't sitting in jail for years waiting for a trial, or even if they're not in jail, having this burden pending on their lives and their families for years, is implement a rule that says how long they need to be, how long a case.
Hold on one second.
Am I losing you? Okay, I'll continue though. So how long a case should be brought to trial within a certain period. So in Florida, for example, has a speedy trial rule. If you're charged with a felony, from the date of your arrest, a clock starts ticking. And within 180 days from that arrest date, you must be brought to trial, or else that case must be dismissed. Of course, there are exceptions and some extensions that can be made when there's a need to. And of course, as the defendant, you have that right. So you can waive that right and take all the time you want and then demand a speedy trial later. So that is one thing that, we believe at South Carolina for criminal justice reform is something that's needed in South Carolina. How do you feel about potentially having a rule for a speedy trial in South Carolina?
I'm 100% behind it, period. And years ago, I was on a committee that Chief Justice Toll put together to reform our rules of criminal procedure. And that was one of the things that we discussed in depth. Depositions was another. And both of those things would be so helpful to our system. They would be very expensive, but it could transform our system and make the quality of the work that we do, the quality of our cases, and with quality goes dismissing cases. As I said earlier, it's not all about convictions. It's about weeding out cases that shouldn't be prosecuted, and having depositions would be tremendous.
And so for those who don't know, a deposition is when you, as an attorney, get the opportunity to ask questions to witnesses before a trial, or to learn information about the case. So both the defense and also the prosecution learns the strengths and the weaknesses in the case. There are many times as a defense attorney when I did depositions that I learned, this is a terrible case for us. We need to plea, so a lot of people.
This is very credible. She didn't seem so good on paper, but gosh, I listened to it or watched it or read it. And let me ask you this: in Florida, when you did depositions, was a deposition later admissible in court? Hello?
No, it could only be used for impeachment purposes.
Okay, well, that's still.
Can you hear me? Okay, yeah, it could only be used for impeachment purposes, the deposition. There were some very rare instances, obviously, I think maybe if someone was deceased, maybe I had never experienced that, but it was only for impeachment. For example,
I mean, we
in
need
civil cases, civil cases in the state, if you're in a car accident and you get an attorney who's a plaintiff's attorney, they get to depose all the parties. They get to ask all the questions. Here, if you're charged, with a serious criminal offense, you might not know what a witness is going to say until they get up on the stand on your trial day. It's pretty bad. So I'm so happy to hear that you are in favor of them as well.
Yep.
And of course, for the state, it's also helpful too, because they may learn other information and weaknesses in their case, which would expedite it. And then, a case that might have ended up going to trial that wouldn't have been successful, they can maybe resolve a case earlier.
I don't know about criminal defense lawyers, but prosecutors, good ones, don't like surprises. And depositions
we hate surprises probably more. Well, thank you so much. And I have two last questions for you, and I'm going to let Keith go, but short ones. Why is, I don't know the answer to this, and maybe you do. Why is a prosecutor called a solicitor in South Carolina? We're the only state in the country that has that. What is that? You know why?
I think it's just the old English holdover.
So we still stick with that. It sounds nice though.
We're
I like
clinging. We're clinging.
I like it.
Simple as that, right?
And so solicitor in England, you know, and in England, a solicitor is an attorney. Is not, I think there's a difference between one that's in trial and not. I think that's the one that's not. But obviously we originally, you know, English, British influences, and that was the original term for that. And we stuck here.
Yep.
And then my last question for you, for me at least, Scarlett, is what was it that made you want to be a prosecutor?
I think, you know, at the end of the day, what I enjoy most about this job is feeling like I have an opportunity to do the right thing and to help people when they need help. And the right thing can look different. The right thing can be getting a conviction and sending someone to prison for a really long time. Sometimes that is necessary and is important to the community as well as victims. It can also mean finding a case that should have never been charged and dismissing it. But getting to work with people who are counting on you, I like that responsibility of knowing that somebody's counting on me and that I can help them. And that for me is the most rewarding part of doing this job.
Yeah, I have a tendency of saying, oh, I mean, I just think it's true. Prisons are not made for all people, but they are made for some people. And there are definitely some people who do deserve to be in prison. So I can agree to that. Definitely, I appreciate you coming on, Solicitor Wilson. It's been great working with you. You know, on this arbitration program, I'm so excited about it. You know, probably won't stop talking about it. I can't wait to get the certificate so I can show it all off to everybody. But definitely, again, great working with you with CJCC, among other things. It was just an honor and privilege to have you here.
Well, thank you so much. And I appreciate both of y'all for doing this. I mean, this is your free time and also your work with the CJCC, because we're on to something there and we can lead the country.
Definitely.
Yes, and we're going to be hosting the CJCC hopefully in the next few weeks. We're looking forward to that. And we're going to talk all about what they do and the work that they've been done and the help that we need to achieve the goals that we have been pushing for a few years now. But Solicitor Wilson, thank you so much. This was such a pleasure. Thank you for your honesty and for coming on and your transparency. You know, also, you all can check out the website for the Ninth Circuit Solicitor's Office. You can find out the data points that Solicitor Wilson was talking about if you want to learn about the racial bias things that she's doing there, learn more about how the Solicitor's Office works. And obviously the arbitration program, I think, is probably available on that website as well if you're interested in becoming a volunteer.
Definitely. I'll be lobbying and trying to get more volunteers. So.
Much, Solicitor.